Good afternoon, Judge.
Good afternoon, Your Honor.
I heard you earlier, you did not reach the age of 70.
Yes, Your Honor.
You retired at 63.
Yes, Your Honor.
What was the reason for your early retirement?
I was considering other options, Your Honor. And at the time, I already believed that I have done my share in government service, and it is time to change gears. And of course, Your Honor, I was already thinking of going into the academy, which I thought would be a new kind of experience and ministry for me. Well, I think I was correct, Your Honor, because I was elected president of an autonomous university with 12,000 students and 500 faculty and non-academic personnel. And it was a fulfilling experience, Your Honor. You see, Your Honor, the life in the academy is a proactive life. And a university has three trifocal functions: instruction, research, and extension. And this provided me a new opportunity for self-fulfillment. It's a new ministry. It's a new adventure in service. Believing, Your Honor, that education is still the best passport to a better life, the liberating means for people to get a better life is through education. And to be a part of the educational process, to me, is fulfilling.
Now I will ask questions sent by my colleagues, the retired justices. First question is, can you distinguish the right to remain silent and the right against self-incrimination? What is the distinction between the two?
These are actually, to me, Your Honor, confusing concept. But the right to remain silent is a broader right, and the right against self-incrimination is only invoked in instances when the answering would result to in criminal prosecution. That is my limited understanding of these concepts, Your Honor.
Did you teach in college?
I was a university president, Your Honor.
You did not teach.
Well, at one time, Your Honor, there's a law school in the university, and at one time, I lectured on land titles and deeds.
I see. We will not cover that now.
Yeah, thank you.
Second question is, does the office of the Ombudsman have legal standing to intervene on appeal in administrative cases resolved by it? It was the office of the Ombudsman who initially resolved it.
I think the trajectory of the rulings here are two-pronged, Your Honor. There was a decision, I think, in 2008 and 2011, I think. One says that the Ombudsman is just like a court. When it renders a decision, it did not be part of the appellate proceedings. But there's also a decision later that the Ombudsman should participate when its decisions are being assailed in the appellate proceedings. Whichever way, Your Honor, I am open to a discussion on it and explore the best way forward.
Your personal opinion?
My personal opinion is that the Ombudsman is like a court. Its decision is there and it is up for the appellate court.
So it should not intervene?
It should not intervene.
Yes, sir. You were referring to the Bongais case?
Yes, Your Honor.
Sa Maniego?
Yes, Your Honor.
Okay. Can the doctrine of condonation be applied motu proprio by the office of the Ombudsman? I'm referring to acts committed before the abandonment of the doctrine in the case of Vice President Binay. Mayor Binay.
Your Honor, I think the ruling of the High Court there is condonation does not apply.
Yeah, the question is, now in Binay, the doctrine of condonation was already abandoned.
Yes, Your Honor.
The question here by my colleagues is that can the office of the Ombudsman motu proprio apply the doctrine in favor of a respondent or an accused?
No, Your Honor. He should not. I submit that the Ombudsman should not motu proprio.
Not.
Yeah.
The Supreme Court agrees with you. The Supreme Court agrees with you.
Thank you, Your Honor.
How about, is the final and unappealable decision of the office of the Ombudsman still be the subject of judicial review? Can it still be the subject of a judicial review?
In the finding of probable cause, Your Honor, it should not be subject to judicial review except when there is grave abuse of discretion. In the administrative adjudication of cases, there is an appeal allowed through the Court of Appeals.
Executive Order number 226, institutionalize command responsibility. What elements do you need to prove to make a superior liable for the acts or acts of subordinates?
The question is what
elements do you need to prove to make a superior liable? What are the circumstances?
Generally, Your Honor, I believe that a superior officer is responsible for the work of his team. he must be responsible for the work of his team. Now, insofar as circumstances that would exempt him from being
No. When does the doctrine apply? Yun na lang.
okay.
I'm not asking if the superior can be exempted. What are the elements? What are the elements in order that a superior may be liable under this doctrine?
Specifically, Your Honor, I believe the compelling circumstances would be the character of the act in such a way that the superior officer has access and participation to the act of the subordinate, then I believe
That participation, the doctrine does not come into play. The doctrine of command responsibility comes into play when the superior has no direct participation, but he has committed negligence. He was aware of the acts of the subordinates. And may okay lang dyan.
yes, Your Honor, he must be negligent.
You have you've spoken about you've touched on corruption earlier. What do you think is the corruption in the Philippines? Is it endemic or is it prevalent?
Both, Your Honor, it is, to me, it has taken
There is a difference. What is the difference between endemic corruption and prevalent corruption?
endemic.
If you know only.
Endemic to me, Your Honor, is that it is systemic. Prevalence is the widespread character of corruption. I think that is the distinction. I hope that is acceptable, Your Honor.
Anyway, I heard you earlier. What is the cause of the corruption in our country? Is it the system or the individual?
I would like to say, Your Honor, that the system to a greater extent. Of course, the individual is the ultimate actor here. But he acted under an environment that enables him to commit corruption. So
we change the system.
So we have to correct the system. We have to correct the system to make it very difficult for individuals to commit.
At this point, what do you want to propose? What do you intend to do to change the system? Do you have anything in mind?
Well, Your Honor, there are a lot of ways to do this. As far as I am concerned, number one, it can be a legislative reform. Number two, it can also be an interagency cooperation between the agencies of government that have something to do with corruption. I mean, as gatekeepers or safeguards or guardians so that corruption will not happen. So, legislation is one, interagency cooperation is second. Number three, there has to be a moral regeneration. This is, again, maybe quixotic, but there has to be a moral regeneration. And when we talk of moral regeneration, we start with ourselves.
So, no longer the system but the individual.
In a way, also, Your Honor.
Last question, Judge. As a judge, have you faced a conflict between the letter of the law and the spirit of justice?
I am not sure now, Your Honor, but it must have happened. My context on this, Your Honor, is that the High Court, reading on I did a little review on the jurisprudence involving the Ombudsman, Your Honor. And I believe in the fact that somehow the Supreme Court has veered towards the context of, or judicial philosophy of, a living constitution, rather than the judicial philosophy of textualism or originalism.
As a judge, your personal experience.
I cannot remember anymore, but I must have encountered that. And if Your Honor asked me how would I have behaved in the face of a conflict between text and the spirit, I would take the side of the spirit of the law rather than the text of the law.
Thank you very much, Judge. That will be all.
Thank you, Your Honor.